Welcome to the Setting the Standards, How to Measure Your Bar's Success. While we're admitting people, we're just going to wait for a few minutes. Then we're going to have a little commercial from one of our sponsors. So come on in and get comfortable, and we'll start that in just a minute. Welcome, everyone. I'm Patrick Pallas, and this is Setting the Standards, How to Measure Your Bar's Success. I'm the past president of the Washington State Bar and a former member of the National Conference of Bar Presidents Executive Council. So this is part 2 in a series. Last February, we introduced you to the importance of data in bar leadership and how you can use data for program creation and implementation and for evaluation. And we recognized this simple truth: you can't manage what you don't measure. And so we've built this workshop around those ideas. Now, we also discussed last time the most usable metrics in bar associations for performance, for things like CLEs, bar due projections, budget analysis, committee programming, new programs, creation and sunsetting, but also importantly focused on key data metrics when profit or when revenue really aren't the best measure. I'm talking about things like access to justice or public service programs. So today we're going to dive a little deeper and look at more programs from bars and from our judiciary from around the country. We'll share examples of the importance of collecting data and setting data standards, particularly in the area of legal innovation and access to justice. During this presentation, I invite you to ask yourself these questions. How will you define success for your bar programs and services during your term? Has your bar created a set of metrics to measure the success of your access to justice, your public service, and your legal innovation programs? Does your bar have tools to collect the critical data you need to define success? So before I introduce the panel, let's talk just a minute about one of the biggest legal trends that's occurring, not just in the US, but in Canada. To date, 10 American jurisdictions, 3 Canadian provinces, the American Bar Association, and the Conference of Chief Justices have either taken significant steps towards encouraging legal regulation reform or have launched task forces to examine reform, or are actually implementing changes like in Utah and Arizona, and now most recently in Florida. These changes are getting a lot of press. I'm seeing it in blog posts, I'm seeing it in articles, I'm seeing it in conferences like this. And this month, the ABA GP Solo magazine has dedicated an entire edition to re-regulation in the law, which will discuss this trend from the perspective of state Supreme Court Chief Justices, a legal ethics professor, CEOs of legal technology and legal service companies, ABA leaders, including intermediate past president, and more. Among the issues being discussed at bars like yours and at judicial conferences and among state Supreme Courts is how we best measure legal innovation and how we quantify success. Everyone recognizes that well-designed data collection utilizing clear data standards is critical. Data collection will help us answer questions like these that I think many of us have. Can re-regulation create more jobs, serve more people, grow our legal economy? Are legal sandboxes effective, and will law firms and bars benefit from them? Can we really change the rules and create better protections for the public? Is there an opportunity to bridge the access to justice gap while growing the legal economy, both for lawyers and for the public? There's a lot of talk about these things going on. And so Because there's so much that we want to talk about, let me introduce you to our distinguished panel. I want to note that the full bios of our panelists are all highlighted in the People Navigator on the left of your screen, and I encourage you to check those out. First, let me introduce you to Michigan Chief Justice Bridget Mary McCormick. She was elected to the Supreme Court in 2013 and became chief in 2019. Before being elected, she was the dean of the University of Michigan Law School. She currently serves on the Conference of Chief Justices as the chair of the Access and Fairness Committee. And for those of you on Twitter, you can follow her and tweet out today at Bridget Mary MC. Next, we have Don Bivens, who is the principal at Don Bivens PLLC. He's a mediator and arbitrator in business litigation, past president of the Arizona State Bar, past member of the ABA Board of Governors, importantly, a member of the Arizona's task force on the delivery of legal services, and currently the chair of the ABA Center for Innovation. You can find him on Twitter at Don Bivens AZ. And last but not least, Zach DeMiola. He's the director of legal education and legal profession at ILES, which is the Institute for the Advancement of the American Legal System. ILES, if you don't know already, is a national independent research center at the University of Denver dedicated to facilitating continuous improvement and advancing excellence in the American legal system. You can follow Zach on Twitter at the letter Z_Demiola. So welcome all of you. So glad to have you as part of this conference. Justice McCormick, if I can have you join me and start us off, can we talk a little bit about why data collection is critical and why bar leaders are important partners? I'm going to turn the stage over to you.
Thank you very much. Thank you for the introduction, Patrick. Thank you all for including me in this conversation. It's always exciting to be on a panel with Don and Zach, and I'm looking forward to your questions and comments. I'm going to share my screen and make myself small and my slides bigger. I'm going to talk a little bit today about the importance of data to innovation and performance, not just in the legal profession, but in what courts do specifically. And then I want to talk about the problems with judicial system data, why we should all care about those problems and those gaps. And I'm going to give you some specific examples from my home state of Michigan, where we have come into contact with those problems. I'm going to give you my 2 cents on barriers to building better justice system data, and then I want to talk a little bit about why I feel like we're at a really important inflection point right now, where we can make some big progress, but we have to do it together. Our data and your data, the court's data and the bar's data are dependent on one another, and our performance is dependent on one another. And I think we have a moment right now to make some real progress. The big picture is, of course, that building a statewide legal system data infrastructure foundation will allow us to increase access to justice, increase transparency, and at the end of the day, measure whether some of the things we're doing are making a difference to the public we serve. This moment we're in, where we've seen more change in the last 16 months than we have seen in many decades, gives us real opportunity. If you've ever heard me talk about what's happening in courts, I've said many times that this pandemic was not the disruption we wanted, but it was perhaps the disruption we needed to learn that we're capable of innovating, and we're capable of changing, and we're capable of collaborating in ways that were not always obvious before. So let me give you a quick overview on Michigan and the sort of barriers to excellent judicial system data. We have a decentralized judicial system in Michigan. There are over 500 judges who sit on 242 different trial courts and use 130 different computer systems, 20 different case management systems. which means that the data collection we see is cumbersome, it's inconsistent, it lacks uniformity, and it lacks transparency. It is very hard to build a transparent, consistent data collection system with this kind of decentralized judicial system. And it matters. I'll tell you why. We have all come across problems in our judicial systems over the last, well, probably as long as we've been practicing, but in particular in Michigan, I'll tell you about a couple of them. We knew, like many states, that the jail population in our county jails in Michigan had grown significantly over the past 30 years, even though crime was at a 50-year low. We didn't know why. And the reason we didn't know why is because there are 83 counties in Michigan, 81 county jails, and 81 different systems for collecting jail data. With the help of the Pew Charitable Trust, we were able to actually collect the data to be able to analyze what was going on, and a bipartisan state and county level task force with really diverse stakeholders was able to make a series of recommendations to the governor, which resulted in 20 bills being signed. This was one of the most successful task force processes I've been involved in, and I've been involved in and am involved in a lot. And those new laws are going to have a tremendous impact on our jail populations in Michigan. You can read the report in my after our presentations, I should say. But I will say that the final recommendation of the task force was for more robust and better criminal justice data collection, so we can measure whether these new laws, these new innovations, are making the difference that we hope they will. Similarly, like every other state in the country, Michigan has lots of people who have civil legal needs and have to figure out how to manage those needs without lawyers. Michigan is not different than any other state. We know nationally 7 out of 10 low-income households report at least one civil legal problem in the last year, and in nearly 9 out of 10 of those, they receive no or insufficient legal help. We do know that in 3 out of 4 civil cases, at least one party is self-represented, but here in Michigan, I can't tell you how many people were not represented in landlord-tenant cases last week, last month, last year. We don't know exactly how many eviction cases or how many writs of eviction cases were served even. That's not data we now have statewide. We know it's a lot. We know, for example, in Detroit, only 4% of tenants in a short study in 2017 were represented by an attorney, while 82%, I believe, of landlords were. But we don't have a way to answer those questions about our statewide processes. That makes it really hard to measure anything we're doing to try and help people in those cases. The Justice for All task force that we launched before COVID made a number of recommendations for streamlining and simplifying court processes, as well as testing and implementing new ways of delivering legal services. But without data, it's going to be hard to measure our success. Impossible, I would say. Similarly, we had a pretty successful bipartisan task force looking at trial court funding in Michigan. Because of that decentralized system I talked about at the top of the presentation, local jurisdictions are funded locally, and that means that local courts are often charged with funding their own processes, their own courthouses, their own staff. This leads to significant public trust problems. And the Trial Court Funding Commission recommended, among many other recommendations to address this funding problem, a connected infrastructure, a technologically connected infrastructure, so that we can not only push improvements across the state uniformly, but collect data to understand what's happening. We just launched in Michigan a bipartisan task force on juvenile justice reform. Right now, every county in Michigan has its own set of processes for handling juvenile cases. And we literally have no data to be able to measure how those different processes are doing. Just like with the jails task force, we would not be able to figure out how to measure what reforms make sense on our own. So we are lucky enough to have engaged the Council of State Governments to assist us with both collecting and analyzing the data. If you've heard me so far, we have only been able to collect and analyze data about really important justice system problems by engaging outside help. I think there are a bunch of barriers to why we don't do better with justice system data. There is always a funding issue. I have been making a lot of pitches, especially lately with American Rescue Plan funding on the table, about building a judicial technological spine to be able to both collect the information we need and measure what we're doing, as well as push reforms in a statewide uniform way. I also think judicial infrastructure is infrastructure. So I'm talking whenever I can about funding, but funding is always an issue. We haven't always been good at collaborating with the other stakeholders in our justice system, and we have to get better at that. I think inertia is a really powerful force. There is a lot of "we've always done it this way" that I hear when talking about doing things different ways. And there is understandable fear of exposing things that are not going well. And finally, I think our culture gets in our own way. There is a lot that is lovely about tradition and respect for the past, and that drives our approach to a lot of what we do. And it also, in my view, stifles innovation. But this last year, we saw that it doesn't have to. Michigan, like every other state, moved all of its court processes quickly online. We were lucky; our trial judges already had Zoom licenses. We had to make sure everybody understood what to do with them, but we quickly figured out we were going to live stream to YouTube, and we have had more than 3.5 million hours of Zoom hearings since late March of 2020. We quickly built this virtual courtroom directory where the public could click on any of those counties in Michigan and see which judges were operating live in their Zoom courtrooms, and then click directly on the YouTube link to watch what was happening in those Zoom courtrooms. We had 17 counties operating an online dispute resolution platform before the pandemic. And in 3 months' time, we expanded it to every single county in Michigan. And now every single person in Michigan has an option to choose an online dispute resolution option for free. It's asynchronous and can be done from any device. We worked together with the other branches of government to use American Rescue Plan funding to put the entire state in an eviction diversion program. That took collaboration that we are not always used to. But it's been tremendously successful. I don't want to use up much more of my time, and I'll be around for questions, but I want to leave you with this pitch. This is a really important moment. We are at an access to justice crossroads, in my view. We have learned that we can innovate. We have learned that we can collaborate. And we've learned that when we do it, we can increase access to justice and transparency. And if we do that, we can build public trust in our profession, in what we do in court, in what you do in your offices together. It's a unique moment. We have to move ahead together. Your data and our data are connected. I look forward to this discussion. Thank you for having me. Patrick.
Thank you very much, Justice McCormick. Love the presentation. Appreciate your time and your energy. Let me bring on Don Bivens. Don, if you'll join us. Don is the chair of the ABA Center for Innovation. Don, there's a lot going on at the center right now. Will you talk to us about what's happening?
Sure. Well, today's theme from my perspective is try not to mistake the edge of your rut for the horizon. And I'm going to try to introduce you to some resources that the ABA has that I hope you will use in your year as bar president and president-elect. I sat in the same seat you're sitting in some 20 years ago. I understand the issues of trying to move forward in a positive way, but I guess I'm asking you to measure yourself against what you're about to hear. And if it's stuff you don't know, it's time to start reading a little bit. And I'm going to commend to you the ABA Center for Innovation website. I had hoped to be able to show some of that to you live here, but technology was not our friend today. But it's not hard. All you have to do is go American Bar Association Center for Innovation, and it'll pop up. American Bar Association Center for Innovation. Let me tell you a little bit about us and how I think we might be of use to you as you measure yourself against some of the things that we're doing. The Center for Innovation, I like to say, operates at the intersection of several things that the ABA is concerned with. Of course, the practice of law, of course, technology in the law. We are looking at regulatory innovation and also social justice, and where those things come together, where you will most often find the center's work. And the social justice aspect of it is exactly what the Chief Justice was just talking about. It's the justice gap, and we won't take this audience through why that exists. We know it does. And I'm going to talk about things that the center is doing, and I'm going to gloss a bit at the end on things that Arizona is doing, so that you have a perspective there that may be a little different from what you heard already today from Utah. Patrick said when he got started that the Conference of Chief Justices and the ABA have both encouraged innovation. And I want you to think about that for a minute. I mean, there's 50 votes in that Conference of Chief Justices. There are hundreds of votes in the House of Delegates. And having been there for a long time, I can tell you there is a huge diversity of opinion in there. And for those of you who don't know, most of the House of Delegates come from where? The state and local bars. That is why it was formed. There are some ABA entities and positions that also have seats, but the great majority is from state and local bars. And a unanimous version of that, a unanimous group of a vote in the House came out in favor of basically the following proposition. There's a justice gap. It is time for states and jurisdictions to start to experiment with ways that to innovate from a regulatory perspective to try to address the justice gap. And we are not changing the ABA model rules. That was sort of the compromise that finally led everybody to say, yeah, I can do that. But a couple of states were already ahead of the curve, Utah and Arizona. Many other states have now joined it, I think, taking some comfort and protection behind what the Conference of Chief Justice and the Arizona House has already done. The House version of this did not take a stand on any particular innovation as being more important than another. It left it up to the states to make those decisions. But how are we going to know in 5 years whether Arizona really made a difference? Is Utah better? How about Florida? Will California be coming along shortly? What's going on in Minnesota with their new non-legal service provider availability? So what we have done at the center, and I think this can be a resource to you, is that we do a regulatory survey of the United States. And when you get to the website, you will see a map of the United States. And all you got to do is point and click on any particular state. It'll tell you right where people are in terms of innovation, where they have a task force formed, whether they have rules out for comment, whether they've actually passed rules and are implementing them. And it's a quick way for you to see where your state falls in the panoply of what's going on out there in the real world. I'm going to talk to you a little bit about Arizona's perspective on this, because it's a little bit unique. And if you heard from the justice this morning about the sandbox in Arizona, sandbox in Utah, there's no sandbox in Arizona. Arizona took the leap, and it is now the rules, period. There's no time limit on it. And the two things I like to talk about today in that regard, while there were many things that were tweaked, are Arizona lawyers can now share fees with non-lawyers. In Arizona, non-lawyers can own a portion of a law firm through a structure called an alternative business system. And also, Arizona has formed a new tier of legal services provider to be called a legal paraprofessional. And these folks will have, by virtue of training and experience in testing, If they can prove they have the acumen for the subject area, they'll be talking about family law. They'll be dealing with small claims court, which in Arizona is generally less than 5,000. And they'll be dealing with criminal cases for which there is no incarceration on the table. And then a certain administrative agencies are free. We were thinking in terms of people who need their hand held through licensing or compliance kind of issues at a state agency. From what we could tell, the public was massively underserved in each of these areas, almost everybody appearing pro per. One thing we didn't think of, but we amended later, was bail hearings. It turns out that at 2 o'clock in the morning, that's when a bail hearing usually happens in Maricopa County. The only person there is the person who's under arrest and the judge. And it turns out if that person has a legal representative, they get bail significantly more often than if they don't. And it's hard to get lawyers there because lawyers typically want a flat fee for the entire service, not just to come down for the bail hearing. But we allowed legal paralegal professionals to come in and stand for that bail hearing. That's the only representation you'll have of the person. But if, let's just say it was $100, you did five a night, it's not a bad living. And we're hoping that we can provide more people with more legal representation at a bail hearing and thus advance their cause. So let's talk a little bit about alternative business structures and what we were thinking about in Arizona for as a way to address the justice gap in a way that non-lawyer legal services providers would not. The general consensus after study and talk was that it's hard for most lawyers, except the largest firms, to accumulate much capital. And therefore, it is difficult to finance large changes in the way people do business, because for the most part, lawyers run on this is what it costs to run it. The rest is for the lawyers. There's zero profit at the end of the year. So we were designing it to have to be attractive to capital from other sources, and we thought that innovation from places other than lawyers might also be useful in finding ways to provide legal services more efficiently, probably with more technology, more uniformly, and therefore raise the level of service overall for people who were not able to afford lawyers. And that's what's happening. But let me tell you what the experience has been to date. We've nowhere near as many applicants yet because we're a little behind the curve from Utah. But the first several approvals, what I would call mom and pop operations, where you have a lawyer and an accountant, they're friends, they want to do business together under one roof, thinking that there'll be synergy between the two, and they form an ABS. We've seen certified financial planners team up with lawyers who are doing wills and estate kinds of work, things that sort of make sense. But what's on tap next for Arizona is a bunch of corporate applications that will be coming to the fore. LegalZoom is one of them. And there are, I would say they fall into the categories of people who are traditional litigation finance companies who now would like to be in a position to participate from an equity position on the services they provide through financial support. There are people who provide services to lawyers, say back office services, or ways to enhance the ability of a case to be prosecuted to its fullest extent. And those legal services providers are beginning to think in terms of, well, I can provide the service, but I could also reduce the fee for my service and take a percentage of whatever my services are doing to improve the lawyer's practice. And some are artificial intelligence, where people have designed predictive algorithms where they think they can predict the success of a particular type of action in a particular type of place with particular types of plaintiffs. And in exchange for that artificial intelligence work, be able to participate with an Arizona lawyer in fee sharing on the results of that case. So those are things that if you go to the center's website, you're going to find out about. And I see Patrick, so I think that means I have to pull the plug, and I will do so, Patrick.
Don, thank you very much. I appreciate it. And I want to bring in Zach Demiola now. And Zach, we've talked from Justice McCormick about the importance of data and where Michigan collects its data. Don with the Center for Innovation has talked about how the programs that the center is working on, including data collection and ways to do that and what's happening in Arizona. Maybe you can bring us full all the way around and talk about how it is that we set up an infrastructure to collect the data and make it meaningful. Let me turn the floor over to you.
Thank you, Patrick. And I'm happy to say that as one of the members of the Governing Council for the ABA Center for Innovation, I'm working with Don and with you, Patrick, on identifying specifically the kind of measures that states can look to compare these different innovations and understand what effect they're having. So yes, I'll be brief. I want to leave a little time for us to discuss as a panel, but I'd like to just bring it down to specifics and start with what is the structure for an evaluation. We talk about the use of data, and use of data is critical for policymaking and for identifying the nature of the problems that we need to solve, and then coming up with those solutions and learning, right? Learning from our efforts and others to continually make things better. So the evaluation's got to be the framework. It is the framework for how you understand how to use your data effectively, and you should start with planning your evaluation immediately, right, as soon as possible. So when we're talking about, for instance, regulatory innovation, as we are in the context of this discussion, whatever program a state would be interested in, we at ISLES would encourage them to look at the evaluation right away. Think about what your needs are. What specifically are you trying to address? Is it access to justice? Is it better innovation? Is it both? How does the program work? How can we evaluate the process by which we do the evaluation, right? To know that we're doing this right, we're using the information right. And then, of course, the measures. As we mentioned, the ABA Center is looking into this too. How do we identify specific measures that we can then gauge the impact of what we're looking at? So I'm going to speed through this now. Now, really what I want to show you is, okay, how does the structure for an evaluation really play out? I'm going to use the Utah model as an example. Now, I know that some of the regulatory innovation that's being offered in Utah might be a little controversial, but we're just going to talk about the framework, because I think it's really interesting and it's a great example that ties a lot of themes that Chief Justice McCormick and Don just talked about. So let's move over really quickly. What are they doing really, right? Justice Himonas already talked about risk-based regulation generally. I don't want to go over all of that, but in terms of an evaluation framework, the regulator, the Office of Legal Services Innovation, the purpose of this sandbox, I think, is really just to promote an innovative marketplace. Let's be as innovative as possible, but at the same time minimize the potential and actual harm to consumers. So the regulator within the box has its own set of evaluation. Now, there's a second evaluation that happens too. And that question is, what do all of these things really do in terms of innovation and in terms of impact? I'm going to get to that in a little bit. But for the regulator's perspective, here's a very simple evaluation framework for them. They are measuring harm versus benefit. And they are not, they're essentially licensing discrete services, giving them an exception to UPL or Rule 5.4 or other rules to provide services based on this evaluation. And so the things that they look at to understand if harm is actually occurring, not the potential for harm, but if harm is actually occurring or if benefit is actually occurring, are on your screen now. And by the way, we're going to post a link to my presentation because I'm not going to get through all of these slides, but you're in luck. I tend to do text heavy slides, so you'll be able to read them as opposed just to watching me talk about them. So, they're assessing risk versus benefit to get an overall picture of whether or not this innovation can do more, can do something differently, can reach more people. And again, as soon as there's a threshold of harm that's reached, actual harm, then the regulator steps in, mitigates, or pulls the plug. How do they assess that risk? Here, you see a couple of the different sources for data, right? Consumer complaints, user surveys, secret shoppers, or audits. And then also they're measuring the relative risk of harm compared to the status quo. And what we mean by that is they're taking a look at specific demographics. Now, what the regulator captures is going to be anonymized data based on the people who are using these services, the clients. But they will be able to identify, for instance, if a specific income level or a specific education level or race or ethnicity is experiencing more harm than others, right? And by doing so, they can actually understand if there are vulnerable populations, and then they can address that too. So I said that's what the regulator looks at. They're looking at harm, right? They're allowing as much innovation as possible, but they're closely looking at harm, and they have their evaluation framework to do that. ILS as one of the third-party evaluators. Now we're looking at the model. Does the model work? Does the sandbox do what it purports to do? So what are we measuring, right? We're measuring whether we expand access to legal services. Are more people getting legal services? Are legal services more affordable, right? Consumer protection. Is the regulator actually protecting consumers from actual harm? And then what does the actual harm look like versus the potential for harm? How are those things matching up? You can see there are some other factors in there too that the exterior evaluation will focus on. And here are some of the data sources that we include in our evaluation plan, right? Interviews, right? Surveys, expert reviews, and of course, secondary data from court systems where it's available is useful. I should also say we're going to be evaluating the scalability and the sustainability of this sort of regulation model. Does the Office of Legal Services Innovation, is it structured? Does it work in a way that is sustainable for other states perhaps to create their own models? Now, what are we already seeing? This is the fun part. So every so often, the Office of Innovation Services, I'm getting that wrong, I'm sorry, but you can see in the bottom right-hand corner of the screen, they send out a summary. The regulator of the sandbox says, here's what we're seeing, right? And some of the numbers I think are just fascinating. This is stuff we just didn't know before because we didn't have any opportunity to test it. And that's what a sandbox is. It's a laboratory. We're exploring and testing these things. So 70% of legal services are produced are considered moderate risk entities. Now that risk level that is associated to the legal service provider is what determines what data they have to submit and how often. Some of these entities are submitting data to the regulator monthly, right? And that's the data, if you look back at some of my previous slides, that's the sort of data we're talking about, right? And so that's the currency of the sandbox. You want to play in the sandbox, you have to agree to produce the data that the regulator decides it needs and as often as it needs it based on your risk factor. What type of services are we already seeing provided? A lot of end-of-life planning. I mean, I imagine that some of this might be influenced by our experience in the pandemic, but contracts, entity incorporation, marriage and family, a lot of these issues really were of primary concern. We expect that need for these sorts of topics to continue to increase in the after effects of the pandemic. Well, what else are we seeing? 2,000 unduplicated clients so far. And keep in mind, the sandbox has not been open for a full year. 3 complaints total, and 2 of them are actually related to harm. That's 1 complaint per 1,200 services delivered, right? That is a fascinating statistic. Now, this is early days. None of this is conclusive by any stretch, but every piece of data I just showed you, I didn't have any ability to collect before Utah opened its sandbox because the rules prohibited those sorts of entities from providing those sorts of services to these people who are using them. This is a fascinating opportunity for us to understand how a new market for legal services can work. And just to back up 1 second, another fascinating thing about this to me is Utah opened it up to everybody. Look how many lawyers are participating in these new entities. A whole lot, right? So interesting information, very important. It's a new frontier. We see sandboxes are now proposed in a few of these other states, California looking at them. And I would just say this, as Chief Justice McCormick mentioned, states don't have to go it alone. There's Pew, there's ILS, our organization, there are others who can help with the data, with the evaluation, and so forth. And I'll leave it at that. Appreciate the time and very, very honored to be on the panel with the Chief Justice and Dawn too. Thank you.
Thank you very much, Zach. Appreciate that. So I think there's a couple of takeaways that we can take from this, right? I started out by saying you can't manage what you don't measure. And I think that's a critical theme that runs through this. There's always this question out there, and we'll take a few minutes here to take questions from all of you. But the question always comes up about legal innovation or re-regulation, which is show me the data. Show me the data that it's working. And I see that one of the questions that came up is kind of in that theme. And I want to address that to all of you. And Dawn, if you could join us as well. It's along that same idea. And the question is this: is there any data from jurisdictions that already have employed non-lawyer ownership of law firms that supports the belief that allowing non-lawyer ownership enhances access to justice by the indigent? I open up to any of you to answer.
Well, I'm going to say yes. And remember, it's not just access to justice to the poorest of the poor. We have an access to justice problem for the middle class. And frankly, many lawyers can't afford themselves. So it's a very broad spectrum of provision of services. But when we looked at Ontario, we looked at the United Kingdom, we looked at Australia, and to our understanding, the breadth of services and the number of people being serviced, sort of like the stats that Zach just showed, people will use the service if they think it's good for them, and that. So I think the answer is yes. The corollary to that is it taking food off the lawyer's table? And of course, we looked at that very, very carefully. And from what we could tell, the answer is no. The folks who are not hiring lawyers are never going to hire a lawyer. It's just beyond reach. They need transportation, but they can't buy a Cadillac. And we don't have anything to sell right now but Cadillacs in most jurisdictions.
I want to bring up a brief story about the LLT in Washington. Washington was the first state to have individually licensed paraprofessionals. The program went for a number of years, and then the Supreme Court ended it. And one of the reasons that they ended it, or the reason they ended it, was because it wasn't making enough money for the bar. There wasn't enough money being generated. And that was the basis for the conclusion of the LLT. One of the important factors we've talked about all along through this conference from last year to this year is when you're collecting data and making critical decisions about things like access to justice and member services, that the revenue line may be the least important, at least one that can't be the most important. And I'm wondering if you all have advice for bars and bar presidents as they're looking through their presidency to decide how they measure programs and how they decide and quantify success, that what you're going to use, if you're not going to use dollars, revenue and profit as the basis for your conclusion. Advice for our bar leaders.
I'll jump in, and that Washington example is a classic example of where there's just the regulatory. So you saw my initial slide, sort of regulatory framework or evaluation framework. That's evaluation 101. You need a needs assessment. You need to frame the problem that you're trying to deal with. And I don't think the problem in Washington was framed as, are we making enough money to sustain additional programs for access to justice? I don't think that was the problem. So you have to have a goal, and you have to anchor your efforts to that goal that helps you, and very specific goals, right? How you frame your need will help you to design what data you're going to collect and how you assess whether or not that program or that effort is actually effective. You do not want to change these goals midstream unless after the data and an assessment allows you to say, well, we're understanding that we can improve here. We're understanding that we're doing really well here. And we're understanding that we have a dark spot here that we need to fill in with more information. I mean, that's continue to be iterative. Yes. Continue to improve. Yes. But remember that needs assessment is so important, and be specific about what it is.
So Zach, I'm going to stop here for a minute and bring this portion of our meeting to a close. I'm going to invite you all to continue to look at this question and others for those who want to stay. For those of you who want to stay, you're welcome. For the rest, this is the conclusion of our program, and I thank our panelists very much. And you can all return back to the main stage.